Welcome to Penn State Dickinson Law's Profiles in Leadership series. I'm Daryl Lim. I serve as Associate Dean for Research and Strategic Partnerships, and I'm the Laddie Montague Junior Chair in Law. This series explores leadership through the eyes of judges, lawyers, policymakers, and institution builders as they reflect on their journeys, professional responsibilities, and the lessons they learned along the way. It is a personal pleasure and honor to welcome today's guest, Laddie Montague. He earned his JD from Dickinson Law in 1963 and joined the firm that became Berger Montague at its founding in 1970. Over more than 5 decades, he has served as trial counsel in some of the most consequential class actions in American legal history. He has shaped modern private enforcement and led one of the nation's preeminent plaintiffs firm with distinction. His impact extends far beyond the courtroom, however. Two libraries at Dickinson Law bear his name, reflecting his enduring commitment to scholarship, learning, and the future generations of lawyers. It is also a personal privilege for me to hold the chair in law named in his honor, which stands as a lasting testament to his leadership, integrity, and devotion to this institution. Laddie, it's a privilege to welcome you to Profiles in Leadership.
Thank you very much. That's quite an introduction.
Well, it's easy when it's true. Let's start at the beginning. Where were you born?
I was born in Philadelphia, Pennsylvania.
And what was it like growing up?
Well, I was lucky. I came from a family of, I would say, of well-means. So I was able to go to a private school. I had a wonderful family with an older brother and an older sister. I went to the Haverford School, which was an excellent preparatory school. I made a lot of friends. It was just a wonderful upbringing. And when I was a junior in high school, my father died unexpectedly, and our whole economic system changed. We went from being comfortable to uncomfortable, and fortunately for the Haverford School, gave me a scholarship to continue, and I got a scholarship to Penn. And then I decided to go to law school. And Dickinson Law School was, at the time, $250 a semester. So that's what I could afford to go to Dickinson Law School. And it just so happened that one of my family's friends was a distinguished lawyer who was an early graduate of Dickinson Law School and very, very active there. His name of Ed Polisher. He's a tax lawyer, like a preeminent tax lawyer in Pennsylvania. And that's what got me to Dickinson Law School, actually. And it was he who got me involved in the leadership of Dickinson Law School.
Do you remember any highlights from your time at Dickinson?
You know, the highlight in my mind was my first year forming a study group. And I was with 4 other wonderful people. At that time, there was only one woman in our class of 55 or 56 people. So the study group was all men. But it was 4 out of the 5 made law review, and the 5th made what is the next group? It had just formed when I was there. Wasn't the law review, but there was a second tier of publications. Anyway, we had a wonderful time all through law school, and interestingly enough, all of us did very well, except in one course. All of us got a very poor mark in property. So it shows you the importance of a study group. It helps you get get good grades in school and understand what's going on. And then you understand when you didn't get it.
Well, it certainly does, and students today still form study groups, so it's an enduring tradition. So you
I
graduated. What did you do after you graduated?
after I graduated, I there was a professor, actually, I think he's the dean's chair is named after the professor Don Farage. He introduced me to um, the, a lawyer in Philadelphia by the name of David Berger, who had just left the city solicitor's office and was also a chancellor of the Philadelphia Bar Association. And he had just started a small firm. And um, he introduced me to him, and we had an interview, and he agreed that I could clerk for him. Unfortunately, 2 weeks before I took my final exams, I got a draft notice from the Army because this was during the Vietnam War. So my clerkship with him was very short before I went into the Army. When I got out of the Army, I contacted him. Uh, I got a job for $100 a week because it was a very small firm. And then he merged with a bigger firm of about 30 lawyers. And interestingly, at that time, uh, litigation trial work was like a service to the rest of the firm. It was a service to the clients of the firm. It was not considered a money-making um, arm of the firm. It was just that help clients that got in trouble get out of trouble. Anyway, it was David Berger that, as city solicitor, got involved in the electrical equipment cases, which were the first really big antitrust cases. And also, I think there was one class action that was started during that time. And he got the idea, let's start a class action practice. I I don't think I ever even heard the word class action when I was at law school. I know that Rule 23 was skipped over in the civil procedure class. So it was a whole new area for me. And that's how we got started. And I, uh, it became so, it's an interesting dynamic because in the class actions, they take a long time in order to either succeed or fail. And when we got our first fee and first victory in a class action, it was a case against the rock salt companies for price fixing. And it was under the old Rule 23, which was a pretty antiquated rule where people had to intervene rather than get notice to join the case. Anyway, we got our fee, and because it was like a 4-year wait till we got our fee, that there was a lot of friction in the firm over finances, which I was not part of because I was a very young lawyer. But anyway, it was decided then that David Berger said, I'm going to leave and start my own firm. And would you come with me? And there were 5 lawyers altogether. Him, myself, a lawyer by the name of Herbert Newberg, who you may have heard of because since he wrote the treatise on class actions, which is now like the treatise on class actions, and then two other lawyers. And we started this firm at 5 of us. We moved into an old building, an old townhouse, and renovated it. We used to file papers with dust and fingerprints on the papers. In fact, the clerks of the court used to laugh at us. Anyway, that's how we started. And those early years were the most wonderful years of all because we were just young and we had no conflicts of interest, and it was just a nice time.
It sounds almost like these teenagers during the dot-com era. in their garages with their startups, and you were basically doing a legal startup. How was it like in those early days? And were you thinking about what the firm could become, what you wanted to um, be known for, the kind of culture that you wanted to grow in
Oh,
the firm?
we just had a good time. We just practiced law. We just brought our cases. We had a very good reputation with the courts, which we'll get into, I guess, so down the road. We were very careful in the cases we brought, and we were very careful of how we treated ourselves, treated others that we dealt with, including the courts, the clerks, the judges, secretaries, our opposition, and in long cases, you get you get what you reap. Pardon my voice. Can I take a sip?
Yes, please go ahead. I like that tumbler of yours, by the way. I
I'm
have
sorry.
I like that tumbler of yours. I have one
Oh,
that looks exactly the same.
yes. It shows you that I keep Dickinson close to me.
Yeah, and I like that one in particular. Uh, so you talked about class action lawsuits. How common was private enforcement when you were starting out?
Almost unheard of. I think if it hadn't been for the electrical equipment cases, I don't know if this goes back to the early 60s or late 50s. Um, these were gigantic cases against the companies that manufactured the turbines and the big electrical equipment cases, the big electrical equipment pieces. And it was a landmark case. I think one of them went up to the Supreme Court. And that was the start of it. And it all started in Philadelphia. It was either our firm and another lawyer by the name of Harold Cohn, who was a brilliant lawyer, and he had his firm, and we worked together in a lot of cases. And that was really this. Philadelphia was the hub of antitrust litigation for a long, long time. And fortunately, in the early years, the first couple cases we brought, we were able to bring them in the Eastern District of Pennsylvania because it's antitrust at that time was all federal jurisdiction. There weren't any state antitrust statutes. There are now some, Pennsylvania being one of the states that still does not have an antitrust statute.
Why do you think that is?
I don't know. I actually testified before the state legislature along with Dolores Corman of Sloter of the Cohn firm, and she later became a Third Circuit judge. And I thought we made a good presentation, but nothing ever came about. There was too much pressure from industry.
I'm going to take a sip of water too, so feel free to take a sip whenever you like.
Okay.
Now, I imagine going back to the time that Pennsylvania was just starting to build its reputation as the hub for antitrust law. You needed not just to have lawyers who were sophisticated, the judges also had to be good at what they were doing. How did the judges build their expertise?
Well, that's an interesting question. And the first judge we had was Judge Joe Lord, who had been a plaintiff's lawyer from a personal injury firm. So he was willing to explore this thing. We brought a case against the book publishers of library books. They make special binders for libraries when they publish books. And there was a price fixing case. And we had a judge who basically announced to us, I will never certify a class action. And indeed he didn't. And it was interesting that one of the shifts in major litigation is, I think it was sometime in the 70s, early 70s, maybe early like 1970, there was a statute passed called the multi-district litigation, judicial multi-district litigation statute, where if you had different actions that were similar filed in different districts, they would all be consolidated in one district before one judge. So fortunately, in the library books case, there were a series of cases filed elsewhere in other places. And the cases were, the statute had just been, or the statute had just been passed. And we went to Chicago, and there we were before a judge who had one of the electrical equipment cases. So he was receptive to the idea, but it really depended. There were judges who just didn't like class actions at all, and there were others that gave you a fair shot, and there were others that kind of thought, "Wow, this is going to be fun." I think I can't speak for judges, but that's the attitude I felt. There were some judges that just sort of,
Well, I'm
"Oh,
glad that there were judges that thought it'd be fun because that made all the difference. And you alluded to this earlier on, but I want to come back to it now. You were building a firm and you're also building a reputation for a firm. And even today, the firm has a reputation, and you in particular have a reputation of being very fair-minded and holding yourself to a high level of professionalism and integrity. Where did that ethic come from, and how important was it as a matter of your effectiveness as a lawyer?
we had that. Well, for me, it came from two places. One, I guess my background, just generally how I was brought up. But two, I remember in the early days when you went to law school, you had a preceptor. I don't think there's a preceptor anymore. And my preceptors told me, one thing I remember, he said, if you have to think about whether it's right or wrong, don't do it. That was his. And then my mentor, David Berger, the person I joined, he just stressed integrity at the highest point. And he said, once you lose your integrity or your credibility with the court, or with the others, or with your opponent, or with your client, you might as well pack it in, because that's the most important thing. So those were always on the top of our list. And we were very, very careful in our briefs, not to make mistakes, not to miscite cases or overstate cases. You can push a case to the limit, but you don't want to overstate it. And I think I know the judges appreciated it. Particularly it was very gratifying when a case ended, and most of our cases ended in settlements after a lot of discovery and before trial. But in class actions, the settlement has to get final approval by the judge. And it was always very gratifying at the end of that process. Almost every judge made very favorable comments about us. And they didn't have to say anything. So it was, and that kind of fueled the way we knew we were doing things right. So.
Were there particular mentors or early experiences that shape your views on being a leader at the bar? Or on the ethics or values that you imbibe? I mean, you talked a little bit about David. Was he a mentor to you?
Oh, he was my mentor, yes. He would, he would, he would, he, he would allow, when I started, I was very raw, to say the least, as a lawyer. And he would always let me go to court to hear the arguments. On any case where I helped on a brief, I would go to court to sit at the table and hear the arguments. He eventually gave me cases to argue, depositions to take. And I would critique. I get a critique from him. And actually, the most ironic thing in my career was the first deposition I ever took in the rock salt case. The lawyer from the other side, after the deposition was over, he knew it was my first deposition. He called me after the witness left. He sat down with me. He had 2 pages of notes on critique. And he gave me a critique of my deposition taking. And that is highly unusual. This is the lawyer on the other side.
Sounds like he was trying to
Very
help you
helpful,
out.
huh?
Yeah, sounds like he was trying to help you out.
It was very helpful. And there was a certain, it's funny, I don't think it happens as much today, but in the earlier times, in the 60s and 70s, and even in the 80s, you fought hard, but there was a camaraderie amongst both plaintiffs and defense lawyers. And you treated each other with respect and even friendship. And I mean, you'd even go have a drink together after a court, something like that, if you had a hard day. But I'm not sure what it's like today. I don't think it's that, there's that feeling. And I think the other thing, this is going to sound off the wall, but the senior lawyers when I graduated law school were all veterans of World War II. And they had all been through a lot. And there was a certain aura about them that was extraordinary. Both plaintiffs' lawyers and defense lawyers. It was an interesting area for a lawyer to grow up in, to be amongst those folks.
Certainly sounds like it. So you served as trial counsel for some of the most consequential cases in the last half century, and one case in particular, I think, will always be associated with your name, and that's the Exxon Valdez case. Tell us about that case.
Gosh, yeah. I still don't know how our firm got involved in it. But I know that I got Dave Berger called me down and he said, our firm just got appointed to be head of discovery, and you're going to be in charge of discovery in that case. So I had no experience in oceanography or shipping lanes or navigation, anything like that. And I went out to Alaska and met with actually we went to Seattle. We all met in Seattle. And I took a major course in the type of law that was involved and started working on it. Oh my gosh, my phone, can we take a break for 1 second?
Sure, no problem. I'll pause it.
And there was a very diverse group of lawyers. There was a lead counsel who was a lawyer from Anchorage. And then there was a lead trial lawyer who was from Minneapolis. And then there was a trial team of the lead trial counsel, myself, and one other lawyer. And we were actually turned out to be the trial team. But before that, I mean, the spill took place in 1989, I believe. And the trial took place in 1995. So that's how long it took to get the case ready for trial. So, I mean, there was a very long, drawn out discovery process and motion process. I mean, motion by the gazillions. You know, Exxon was represented by two very big law firms with excellent counsel. And but it was again, that case, those counsel understood and we understood that this case we'd never get to the finish line if we didn't cooperate with each other. So there was a tremendous, much more cooperation that you'd think, even though everything was fought over, everybody was civil. And it just was a wonderful experience. But that case touched on almost every aspect of litigation, including the introduction of technical equipment in the courtroom. We had one of those big screens, and we had a dais in which you could operate pulling up things on the screen and making diagrams and drawings, and and everybody kind of joked about it because nobody really knew how to do it, but we all tried to thump our way through it. And I think one of the most interesting parts of that case was when the ship left the port of Valdez and went out Prince William Sound to the ocean. And it was on the way out to the ocean that it hit a reef. And the reason it hit a reef was that the captain was intoxicated. So we decided, our clients were all fishermen. So the three of us who were trying the case got on one of the fishing boats and tracked the path of the Exxon Valdez till it grounded, which was kind of fascinating because, number one, it's the most gorgeous area of the world with this sound with these big, huge mountains. They just come right down to the water. And then we went to the fishing village to meet all the fishermen that were affected. And it was a travesty. I mean, that's probably what was never understood by the public, is that the fishing industry, which were people, but literally wiped out. I mean, these fishermen had mortgages on their boats that they had to forfeit. There was fishing went dry. There were suicides. There were marriages disrupted. It really raised havoc with the whole fishing community.
How did they afford to pay you? Did you take it on a
It was all
contingency?
contingent.
Did they offer to pay you in fish?
They didn't pay anything.
Yeah.
But class actions are all contingent. So number one, you have to be willing to either have the resources or borrow and take a chance. And in a sense, it was risky, and that's why there is when you get your fee at the end, you get a bonus. You get a bump from what your normal fee would be, which makes it worth waiting for if you're successful. If you're not successful, it's like a bad investment. So it's contingent fees have been in effect for a long time. But it's interesting that one of the attacks that the defense of antitrust of class actions used was to make contingent fees inapplicable to class actions. And that went through the courts, actually, and was litigated and was successful. I mean, we were successful in defeating it. In fact, one of the cases I haven't mentioned is we represented the state of Connecticut, not in an antitrust case, but in the cases against the tobacco industry. And it was in that case that the defense lawyers made the big argument um, about contingent fees not being applicable to class actions. And the Attorney General of Connecticut at that time is now Senator Dick Blumenthal. And I remember he came into the court personally to argue against that issue in our favor. It was very interesting. Anyway, that was another interesting case that went on for several years and ended in a colossal settlement countrywide. But it was nice because the recovery was based on the contribution that the states made, and we representing Connecticut. Connecticut got one of the highest ratings in the recovery, so it was nice recovery. It was a nice result. Another very interesting case, of which we went into knowing nothing about. I think that's one of the rewarding parts of the class action cases. You get into industries and areas of commerce that you know absolutely nothing about, and you have to learn about it, and it becomes fascinating.
Well, how do you pick up these things? And you need to do it quickly. You need to be able to manage your caseload and your clients. What techniques did you use?
Well, one, you go through, the Epstein documents seem to be lengthy. That's nothing compared to the documents we had to go through. And in the early days, there wasn't computerization and AI. So you went through every document individually, and we used to have microfiche or microfilm to go through these documents. And you learn actually you learn more that way. You really would absorb what an industry is like and what the people were like. It was fascinating. I was once on vacation in a small country, and we had a case against an insurance company. And lo and behold, we're sitting down to breakfast, and the person at the table with me was one of the principals of the insurance company. And I had to tell him, I said, I've seen all your documents. We changed the subject quickly.
I was going to ask you what he said.
Yeah, it was very funny. He took it very well, actually, I have to say. But I'm sorry, where were we?
Well, we were talking about how you pick up things about
Oh,
these industries
yeah.
quickly.
And then also we had, you'd have to have expert witnesses because you couldn't go to trial without an expert witness or more than one. So we would have an industry expert witness and we would have an economic expert witness. And the industry expert witness would help us tremendously in understanding how everything worked and what the dynamics were. And the economists were a breed unto themselves. But it's and I had no background in economics either. That was another area that I don't know what law school, how it treats that today, but I always needed help from other lawyers when it came to economics because I didn't have a background in college or in law school.
Well, I'm teaching an antitrust class this semester. I did a poll how many people had a background in economics or finance. It's about 50%. Yeah. So people still learn on the job, and even then, I think antitrust economics is not quite exactly the same as what they teach at the college level.
Yeah.
Yeah.
One of the things that was that was interesting, if you leading up to from, well, I actually started in like 1965 when I actually started getting involved in antitrust cases. And if you go up to like 2000, maybe even the early 2002, 3, 4, you'll see that the development of the law, both evidentiary and the actual antitrust laws and their interpretation, went through a dramatic change. And I mean, almost every 2 or 3 years, there was a Supreme Court case that dealt with either the antitrust laws, class actions, evidence, evidence. And it was a kind of an exciting time because the law kept evolving in so many different areas that affected our practice. I mean, even the Rule 23, the class action rule kept changing, and the rules of evidence kept changing. And it kind of leveled off after 2005 or 2006 in that area. And I think the heavy concentration after that was on how best to obtain the facts. And that's when the AI began to kick in. And it's an interesting evolution in the whole practice of law.
It is.
Work
And
within
I,
that
that's
area.
no, go ahead.
In fact, and I mean, even when there were always in antitrust cases, there particularly price fixing cases, there are multiple defendants. So every time you filed a brief, you had to file multiple briefs. And when we started out, I hate to say this, it was pre-Xerox machine. And we used, I forget what you call them, the mimeograph machines.
Yes.
We had to type our briefs on mimeograph machines and churn them out that way in multiple copies. And then I think we got our first Xerox machine in 1966, maybe 60. And then things began. Then they got the multi-typewriters and the Wang and the evolution of technology and typing. And then down today, of course, it's a whole different story. But it was the whole way of practicing law has changed. I mean, when we had to get discovery and there were millions of documents, we would be taken to a warehouse and have to spend days and days and days going through boxes in a warehouse. Then it evolved into getting microfiche or and then so it's been an interesting change to see how the legal profession has evolved technologically.
And talking about evolution, your firm also evolved during the arc of your career from the first day that you set it up almost like a startup. And today it's probably the firm that people think about when it comes to plaintiff litigation. Uh, Talk to us about that growth.
Um, it is interesting that we started out with 5. We had a building that we had 15 space for 15 offices. We filled that up in about 10 years. And then we had to get space in an adjoining building. And we actually, we went up to as many as 60 lawyers. And then we would say that's too many lawyers. And we'd go down to 40 lawyers. And then we'd go back up again. And finally, we outgrew our space and we had to move into in 2018, I think we moved into a regular commercial high-rise building. So and that was a big change because practicing in a townhouse, and even though it was a big townhouse, was it had a certain quietness to it and a certain comfort level to it. It's like practicing in your living room in an extent, and it was hard to leave it. But I think it was a I think it was very conducive to our practice, and we had this beautiful uh, conference room that looked out over a garden. And actually, the defense lawyers used to enjoy coming to our office for depositions and conferences because of if it was really nice, we could go out in the garden. And it was, I remember once we had everybody in the Exxon, all the plaintiffs' lawyers in the Exxon Valdez case came to Philadelphia in March for a meeting. And it was like 40 degrees out. And all the lawyers from Alaska went outside into our courtyard to have lunch because it was so warm for them.
I think people forget the human side of it and whichever side of it, the litigation you're on, end of the day, people are humans. And I think these types of interactions actually help the cases. But the other part about the firm growing is firms that reach a certain size tend to have to be maybe out of necessity run like businesses rather than professions. Uh, how would you describe the culture at the firm today? Is it more like a business or is it still a profession?
Yeah, that's interesting. I think when Mr. Berger was the head of the firm and when I was the head of the firm, it was not run as a business. We probably were not as economically efficient as we could have been, but it was a nice way to practice law. Today, I think the lawyers who took over are equally excellent lawyers. They're doing a wonderful job, but they are much more uh, economically efficient than we were. And I guess they have to be because they've grown, they've expanded in terms of law firm of offices in other cities. We never had an office we fought against having an office in another city. Uh, so there has been a big change, but when you have a big firm, it's a big responsibility. I mean, you have a lot of people that depend on you, so it's important to have that acumen when it comes to economics.
Yeah. I want to ask you something about something you said when you formally stepped aside from the firm leadership. You said you are not stepping out, you're just stepping aside. Talk to us about what leadership succession means to you and letting go.
Well, well, there comes a time when you understand that the younger people in the firm need to they're more impatient than they used to be than young people used to be, I think. And they really they saw the firm as their own and they were anxious to take it over. And the leadership was all both in there. I was in my late 70s, actually early 80s. Uh, my partners under the next group of partners under me were in their early 70s. And we made an arrangement where each of the other partners would get to be head of the firm for a year so they could have that on their resume. And then we turned it over to the young people. And it's worked out. I mean, the firm is still very successful. Although I'm not involved in it now, I'm not involved in the nitty gritty, but I keep in touch and I know they're doing very well.
You sound like a proud parent.
Well, yeah, it is because, we we have longevity in our lawyers. They come out of law school and by and large, they stay with us. Or they come from defense firms when they're young. They're disillusioned and they want to come with a plaintiff's firm that does our kind of work. And they've been with us a long time and they've evolved and they've all become excellent lawyers and leaders in their own right. One of whom is a Dickinson graduate. We have one other Dickinson graduate in our firm. I don't know why there aren't more, but I don't think we get the applications and the competition's tough when it comes to that kind of litigation.
Yeah,
That's one of the other things that is so rewarding is the lawyers that we oppose are all top flight lawyers, and they really bring out they bring out the best in you.
it's a wonderful way of seeing it. Uh, First of all, I want to talk to you about Dickinson Law because you also played a hugely important role in Dickinson Law, but we are coming up to the hour. Is it okay if we went additional 5 or 10 minutes?
Sure.
Thank you. So you served as chair of the board and later chair of the Dickinson Law Association, and you also played a critical role in the relationship between the law school and the university. Talk to us about those years and what should folks know about leadership in that context?
Well, number one, um, I, there was a I had a there was a group of lawyers, alumni, in the leadership role. I happened to be the titular head, but we had people like Louis Katz, whose picture adorns the hallway, uh, Leroy Zimmerman, first elected Attorney General of Pennsylvania, um, some other folks, and we all worked together to try to hold together Carlisle as the center of Dickinson Law School because it meant so much to all of us and all of the alumni. And to make it to kind of shortcut this, it really was an interesting situation when you look back at it. Dickinson had always been independent and proudly independent. And it was basically run by the Board of Governors, well, I forget what it was called, the Board of something. It wasn't Board of Governors, maybe it was Board of Governors, but it was the alumni group was led with the dean of the school, and Judge Shugart, who was the head of the Common Pleas Court in Carlisle, Cumberland County, was the president of the school, and it was a very close, well-run organization. And there came a time when an independent school just couldn't survive economically. Penn State, on the other hand, is like a country. It's a huge entity and a huge institution, and it's used to having its own way of doing things. And I think there was just this clash of Penn State wanting to be in control, even though they agreed that the school would remain in Carlisle forever, in perpetuity. And there just became this clash, and I think both sides didn't know how to handle it, and dug in their heels. And we had a terrible fight. We had court fights. We had fights amongst the alumni, and all these. We had fights with the then dean and the leadership, and there was this. I call it a steps of maturation. This where they wanted to move the school to Carlisle. We finally reached some compromise where there would be one school but two campuses, and they wanted two schools, and we opposed that, but we were not successful. And now they're back to where we wanted it originally. Actually, we wanted everything in Carlisle, but it's funny how it has evolved back into what we originally envisioned in the first instance. And I think the growing pains have worked out, and I think now it's been a very successful, at least from my standpoint, from afar, it looks like it's been a very successful journey. But it had its rocky moments, believe me. There were times when Penn State threatened to sell the law school, to the highest bidder. And
How did you manage all of that?
We stopped that, believe it or not, by having a conference at halftime at a Penn State football game. But it had a very rocky road. But it's understandable when you think of the background of the two schools. And it's all worked out.
Where would you like the school to go from here?
I think, from what I can see, it's on the right track. And I think really the marketplace dictates how it should go. I understand. There's so many possibilities today with having an education by computer rather than in the classroom. I can't understand it. I can't even understand how one practices litigation law today without being in an office and having face-to-face meetings with your other lawyers in your office and paralegals in your office that are working on cases. So you discuss things as they come up. But apparently that's today, I noticed that lawyers don't spend a whole lot of time in the office.
Or in the courtroom.
Even in the courtroom, right? Depositions are all by the process we're on now.
Yes.
Very odd. It's very nice to take a deposition in a room with a witness and look at them and see if they're fidgeting and see if they're, understand their body language and see what's going on around them, the lawyers. It's a whole different area, whole different scene.
So in this season of your life, what are you focused on?
Me, I'm pretty much retired now. I was the last, about 5 years ago, I resigned as the head of the Dickinson Law Association, which is like the watch guard over Penn State. Because I thought there was a new president coming in at Penn State, and we should have someone who could have a relationship with her. And Tracy Steele has done an excellent job. I just about 2 years last year, I resigned from the board of the Public Interest Law Center in Philadelphia, which I had been a member for about 20 years or so. It's a wonderful organization. And now I'm just enjoying life.
What does that look like?
What does it look like? Well, I spend a lot of time with my wife, which in most of my litigation career, most of our cases were out of town, and you had to travel to go to court. You had to travel to go to depositions. We did a lot of traveling, and she deserves having some time. And my kids are all grown, so my grandkids are scattered all over. I now have one great grandkid, but he's in California, so that's hard. So I'm just relaxing and enjoying life.
Well, you play golf?
I do play golf. Not well, but I play it. It's a good relaxation. And
And yeah.
I try to keep abreast of current events and what's going on in the law school.
And I know many people are delighted every time they see you in person. Uh, and I can only echo their thanks in continuing to be engaged with us in the law school, including for this event. Last word to you, Laddie. Any closing thoughts?
Any closing thoughts? Um, yeah, I take advantage of the wonderful education you can get at the law school. Uh, and in my own case, um, if you have a problem getting initial employment, which I did initially before I got the referral from Professor Don Farage, for reasons I won't go into, but there was a whole different atmosphere particularly in Philadelphia, about law firms and hiring based on religion and ethnic background and so forth. Uh, just stick with it. Do what you want to do, and even if you have to take your first job at a salary that you think is way below what you deserve, if it gives you an opportunity to start what you want to do, think about it and take it if you can. And that's what I did. $100 a week was not a blistering salary to begin with, but I knew that's what I wanted to do, and I knew I was with a a, a good firm and a good opportunity to grow. So if you're at Dickinson Law School, you have a wonderful opportunity. Just take advantage of it.
Well,
And
Laddie,
you have
thank you.
wonderful professors like you.
Thank you. Well, I particularly like the name associated with the professor. And having spoken with you today, having heard about you before, I had a chance to speak with you um, on the many times that we were able to speak. It really underscores why people at the school hold you in such high esteem. And so thank you for this generous and thoughtful conversation. And thank you for your leadership, your example, and your enduring commitment to Dickinson Law. And finally, thank you for joining us on this
Well,
episode of Profiles in Leadership.
I thank the law school for the opportunity it gave me.